Hi, good morning, everyone, and welcome to our webinar this morning. Thanks for joining us. My name is JP Harris. I'm an attorney at Sheehan Finney, and I'm going to be your presenter this morning. We're going to talk about the Americans with Disabilities Act and website accessibility. I am the co-chair of the firm's Data Privacy and Security Group. My day job is as a litigator. I do commercial litigation and employment litigation. And today's kind of the intersection between our employment practice and our data security practice. My data security practice revolves around counseling companies that have security incidents or breaches, the response to those, preparing for those before they happen. I also try to get companies to purge data, not keep so much data to protect. So I work with companies on record retention and data management policies. My partner, Doug Verge, is also the co-chair of the group, and the way we've divided things up, Doug handles primarily the privacy compliance, regulatory compliance, privacy policies. So that's a bit about our group. Today's webinar, we're going to run about 30 minutes. We'll have time for questions and answers, so please type in questions and answers into the Q&A function, and we should be able to get to those at the end. Everyone should know we're going to record this webinar, so it'll be available to you later. Our general disclaimer, we're going to talk generally about some legal principles, but you should please consult with a lawyer about your specific circumstance. So today's topic affects many businesses. We'll talk about the application of the ADA to websites generally, and it does carry a bit of risk, but the good news about today's topic is that this risk is really very manageable with a little bit of preparation and a little bit of thought. But I think the real bonus too is that managing this risk is good for business because it actually will allow your company to provide your goods and services to even a wider array of customers. More people will be able to access your website and get to your goods and services. So it's hopefully a sort of an uplifting topic for today. All right, we're going to do a brief poll, if I can pull this off. And we should have a poll on your screen. The question is, in the last 5 years, my company has conducted an assessment to determine if its website is accessible under the ADA. So I'll give you all a few seconds to weigh in. Okay, here are the results. So I guess the good news for today's topic anyway is that most of you have not had a survey done, and that's fine. We'll talk about the ins and outs of that a bit. So thank you for responding. Let's go back. Hopefully you all can see the screen. Slides again. This is what we're going to talk about today. First of all, we're going to talk a bit about to which websites the ADA applies. What does it mean to be accessible in the context of a website? What are the risks of inaccessibility and how to manage those risks? So that's kind of an overview of what we're going to talk about today. So the first question is, does the ADA apply to your website? Lawyers go to school for 3 years and pay an awful lot of money to learn that the answer to every difficult question is, it depends. So that's, if you want to step into my shoes, anybody asks you a difficult question, you just answer, it depends. That's the correct answer all the time. In truth, the question really is, are you a place of public accommodation under the statute? And of course, we've run into another statute here that was adopted really before the explosion of the internet and e-commerce. So we're talking about applying a statute to a delivery framework that what really wasn't contemplated. If you are an online-only business, meaning you have no physical location into which customers can come in and purchase your goods or services, then there is an argument to be made that the ADA does not apply to you. The question here really is not whether the ADA applies to websites. The question really is, does the ADA apply to your business? And if you fall into the place of public accommodation test, then the answer is going to be yes. The ADA will extend to your website. So really the only businesses that can have an argument about getting away from the ADA are online only businesses, no physical presence where customers come in. Even then, you should know that some courts have held that the ADA still applies to those websites. So if you have a physical location, you have a place where customers come in, your website you are covered by the ADA, and that extends to your website. And I think we have this split about online only businesses. The general trend, I think, at least for motions to dismiss purposes, right, very early on in the case, and whether a complaint states a viable claim or not, I think over time it's just going to become more and more accepted that the ADA applies to websites. The principal case on this topic involves Domino's Pizza, right? We've all been into Domino's Pizza or driven by a few. We've seen the commercials recently. They're sending out autonomous vehicles now to deliver the pizzas to your home. That's a discussion for a whole nother webinar someday. But the principal case is Robles versus Domino's Pizza. The plaintiff in that case was visually impaired. He attempted to order pizzas on the mobile app or website, and even with the aids, his reading software that he used, he still could not, the website did not work for him. So he sued, and Domino's argued, well, wait, the ADA applies to places of public accommodation. We're talking about a website that's not a place of public accommodation. And the Ninth Circuit Court of Appeals disagreed with Domino's and held that the ADA did apply to that website. Domino's attempted to appeal that to the US Supreme Court, and the Supreme Court declined to take the case. So the Ninth Circuit holding is really kind of the law, at least out on the West Coast. And among practitioners, I think the general belief is that the Domino's logic will carry the day in most circumstances. So that gives you an idea about how these cases come about and how courts are looking at them. So what does it mean to be accessible? So again, we're going to take a broad concept from the ADA and try to apply it to your website. But the broad concept is the ADA requires that you can effectively communicate with individuals with disabilities, even by providing them with aids and services at no additional charge. Really the task is you have to be able to remove barriers so that those with disabilities have equal access. This, I'm sure you're all familiar with this concept being applied in places of public accommodation, right? Grocery stores, amusement parks, wherever you go. But taking that concept really kind of crafted years ago and applying it to websites is not as straightforward, and that's what we're going to try to talk about today. So there are, of course, different types of disabilities, and the easiest one, or the one that people most commonly think of when it comes to websites, is visual impairment. But I want to point out to you that really there are more impairments that impact a user's ability to interface with your website, and you need to think of all of them. So visual impairment, let's talk about that. That obviously the ability to see and understand your website is a significant barrier, and there are tools and tricks to make your website more accessible. Those with visual impairment typically utilize a reading software on their side, right, on their computer, that translates text into audio so that they can actually understand the content that you're delivering. But there are also auditory impairments, right? It's quite common for folks to have videos posted on their websites and to use that to market services. So if there's an auditory component, audio component to those videos, and your user has an auditory impairment, they're not going to be able to understand at least the portion of the video that's communicated in that format. There's also motor impairment, which I think people gloss over sometimes, and that's the inability typically to navigate with a mouse. And we'll talk about what the standard really is about allowing those with a motor impairment to get around. Also cognitive impairments. The most typical example that doesn't come up as frequently as it did in the late 90s, early 2000s is a lot of sort of flashing text on websites, but there are other impairments also that the standards are trying to get folks to help remove those kind of barriers. So let's try to be a little more specific, and we'll take visual impairment as an example, right? This is the sort of manifestation of accessibility on your website. The most common tool to make your website more accessible to those with visual impairments is to provide text underlying whatever photos or images are on your site so that the screen reader, the user's software, can read the text that you have supplied with your photo and therefore relay to the user what it is that the photo depicts. There's one caution here, particularly for some industries more than others, but you have to be careful about the accuracy of the text that you append to your visual images, right? There's a whole nother body of law. Let's take New Hampshire, for example. We have a Consumer Protection Act that makes it unlawful to misrepresent, let's say, the quality or characteristics of the goods or services that you sell. So if your text description does not accurately reflect the goods and services you are trying to sell, you're actually stepping on another landmine there. So I have some clients, particularly in industries where the goods and services are, or the item being sold is particularly expensive, and there's a significant amount of concern about, does the text for these photographs, does it really accurately depict what's being shown? So that's a whole nother landmine, but you need to be careful about that. Another way to meet the criteria that we'll talk about in a little bit is providing audio descriptions for the videos, right? It's not just the still images or the photographs on your website, but if you are utilizing videos to convey your content, having some audio description of what's going on in the video is also necessary to meet those with visual impairments where they are. Color blindness or that sensitivity is also an issue to address. Contrasting colors on your website can also make it difficult for those with color blindness or that sensitivity to be able to interpret the information that you're trying to convey to them. So be careful about that. All right, let's talk about motor impairment a little bit. I mentioned this before. The inability to navigate with a mouse, right? The fine motor controls necessary to utilize a mouse, as some folks are not able to move around your website in that way. So the criteria speaks to making sure your website is navigable by a keyboard only. There's also some folks can't move from one part of your website to another with sort of quick motions. And websites today frequently have items that sort of time out or move after a certain duration of time. If you've got kind of a banner, let's say, and things are kind of swiping from left to right at a certain pace, if a user cannot slow down that timing or disable the timing altogether, they might not make it to that spot in your banner in time before it disappears on them. So this is another consideration to allow users the ability to slow the response times. I think we've all, if you go online, well, before the pandemic, we used to go online and buy concert tickets, and you'd start logging in and you'd have 10 minutes to complete your purchase before somebody else could grab those seats. That kind of concept that if folks have a very difficult time filling out your form, for example, and it times out, that's a barrier for folks with motor impairments to be able to utilize your website. Another issue that sort of falls under this category is if your buttons or links or icons are too small and it's difficult for someone to actually get the mouse to that specific spot to click. All right, so we're in a little bit of uncharted territory in that there's no accepted legal standard, right? The ADA doesn't say your website has to have these 10 ingredients or solve these 10 issues. There aren't regulations that are specifically on point for website compliance right now. The federal government has adopted a standard for all of its websites, and we're going to talk about that standard in a minute because it's very popular and it comes actually from the private sector. And many businesses choose to adhere to that. So we're going to talk about that in some detail. But federal websites have all agreed on a particular set of standards, and federal websites are all supposed to be accessible per that standard. But there's no statutory or regulatory adoption of any particular standard. No court has mandated adherence to a particular standard with a little asterisk. We're going to talk about how lawsuits get filed under the ADA if websites are inaccessible, and many times those cases settle under what's called a consent decree, which is basically a settlement agreement, but it's entered as part of an order by the court. And frequently the parties agree to a particular standard and they make that part of the court order, and then it kind of becomes, adopted by the court in the sense that the court blesses the settlement, the consent decree. And so in that context, courts have agreed to standards, and there are multiple. We're going to talk about the most commonly used one, but there has not yet really been a developed body of case law where the courts agree if the ADA applies, you need to adhere to this particular standard. So there's some good news and bad news into that. There's a little bit of uncertainty in that it's hard to tell whether your website is truly accessible in the eyes of all users, but it also is a bit freeing in that you don't have a rigid standard to meet all the time, and you can sort of chart your own path to get as close to compliance as it makes sense for your business. All right, so this is the standard I was going to talk about. It's called the Web Content Accessibility Guidelines. It was the product of a private industry group that had a lot of different constituents brought to the table, right? Advocates for those with disabilities, business folks that wanted their websites to be accessible so that people could purchase their goods and services. This is the standard that it has been adopted by the federal government, and it's the one frequently cited by plaintiffs when they file lawsuits and used by courts and consent decrees, as I just mentioned. The 2.0 version came out in 2008, and there were 38 criteria, if you will, to try to have your website meet 38 criteria. 2.1 is really the version that's being used today, and there were 12 additional criteria to bring it up to a total of 50. I understand that version 2.2 is expected to come out next year, and I don't have enough information about kind of how that's I assume it's going to expand, or at least sort of modify with the way folks deliver their websites these days. And there are sort of different grade levels of compliance. In other words, meeting each of the 50 criteria gets you a AAA qualification, but if you meet some but not all, you're more on the A side. So just know that there's sort of different levels. If you end up talking to a web developer or someone to improve on your website, you need to sort of settle on how many of the criteria you want to meet and sort of what level of compliance makes sense in your circumstance. All right, so I wanted to try to give you an example of what, and you can get this standard online, by the way. It's free. You can just Google it, you'll find it. But I wanted to give you an example of so they're a little difficult to read, frankly. But I want to give you an example of one of them. So this is criterion 1.1.1, and it deals with non-text content. And so let's think about that as like photographs. But what I've quoted for you is some of the language from that criterion. All non-text content that is presented to the user has a text alternative that serves the equivalent purpose, except for certain exceptions, right? So this is what we were talking about before. You have a non-text content, a photograph, and you need to present it with a text alternative so that the user's screen reader can read, right? That's how I would translate that. There are some exceptions, right? Decorations, for example, the CAPTCHA thing, where you got the photograph broken up into squares and you've got to find the traffic lights or the squares with the vehicles in it, right? Those are kind of carved out. But this hopefully gives you a sense of what the criteria look like. The 2.1 version kind of groups what it's trying to address into big categories, if you will. And so I'm trying to give you a sense of the breadth of the standard. There are perceivable items, right? Text, audio, video, information, and relationships presented as text or color, orientation, text size, right? Things that we perceive as users of your website. There's also a whole section on operation, right? We talked about keyboard use, character key shortcuts to make it easier for people to navigate around. Headings and labels are really important under the standard. And then the last big category, if you will, is what they call understandable, right? The language that's used, whether there are instructions inherent in the content of your website that give folks with impairments the ability to understand how to move around and navigate. So that gives you a sense of the organization of it. I wanted to talk, I just pulled out some examples of things that the standard covers. We talked about the text equivalent. A big one is title frames with text for navigation so that folks can understand how to move from one part of your website to another, where they're going, and make decisions without getting lost. Text resizable up to 200%. I think that one's kind of self-evident. We talked about disabling time limits. Titles are really important, right? So people know I'm going to go to this part of your website and I'm expecting to get this particular content. The purpose of a link should be evident from the text of the link. Because remember, use the visual impairment as your example. The screen reader is going to be translating into an audio cue what that link is going to take them to. Keyboard operation, we talked about that. Having the language in which your website presented determined automatically, right? So your website will be able to determine what language is sort of the default language on the user's end. A big one is, particularly for plaintiffs, is broken links that go nowhere. If you can imagine the difficulty trying to move around a website, you finally find the link that you want and it ends up taking you nowhere. The URL's busted or whatever. Redundant links that create these rabbit holes that are difficult to get out of. That's a big one. And labels and instructions. Think about your website, whether your website communicates enough instructions to the user to get around. All right, the primary risk in this space actually is litigation. It's plaintiffs asserting claims that your website is inaccessible. Most of the relief, frankly, is what we call injunctive relief. It's an order, what they're seeking is an order from the court for you to, quote unquote, fix your website to make it more accessible. There are not typically huge damages associated with these cases, but they do include having to pay the plaintiff's lawyers' costs and attorney's fees. And most of the time, the defendants find a way to reach an agreement with the plaintiffs to fix or address whatever the issues are, and the cases are resolved. Those companies that have chosen to fight this have generally lost. There really aren't reported decisions where a company has, either proven compliance or, proven that the ADA doesn't apply. Generally, defendants end up in a position where they fix the website. And the question is, how much money are they paying to the plaintiff's lawyers to have the case go away? So that's why when I started out, I said this risk is really manageable. And I want to pause here and spend some time on this particular slide. Rather than have a plaintiff come to you and identify problems with your website and then pay them for the privilege of them telling you the problems with your website, this is totally within your control. You can do a self-assessment of your own website. There are online tools that you can use to kind of run a quick scan of your site, and it's not sort of foolproof, but they do give you, kind of a grade and identify certain things. Frankly, plaintiffs' lawyers use those online tools on your website, and they get a quick read on whether your case is worth taking or not. But the tools are really designed for you to run them on your own website and run your own assessment. There's no reason to pay somebody else to identify these problems. One possible mitigation tactic is to avoid 24/7 telephone access. In other words, if there's some part of your website that's not accessible or doesn't work, there are some, and again, not many of these cases really go too far, but there's some thinking among practitioners that if you offer this alternative, it really insulates you because, okay, fine, my website didn't work real well, but you can pick up the phone at any time and get access to our goods or services. Like many privacy statements and other policies, you can post on your website an accessibility statement that effectively says, if you're having difficulty, we want to help you. Here's how to contact us. Please let us know if parts of this parts of our site doesn't work for you, et cetera, et cetera. Another thing to consider is to include in your terms of use, in your terms of service, a class action waiver, a jury waiver, and an arbitration clause. And that will prevent big class action matters from getting filed against you. It sort of undercuts some of the economic incentive for plaintiffs' lawyers to take on these cases. These with consumers, the enforceability of these clauses is still a bit of a question mark, but I think it's better to have them than to not have them. to at least preserve the argument, but it might provide some insulation. So how this would work, we all have them on our, by continuing to use our website, you agree to the following terms. You'll have your privacy statements and all those kind of things in there too. But you'd probably have a clause that says if there's going to be any litigation, you're going to sue us wherever you're located, in New Hampshire, for example. But this would be kind of an addendum to that part of your terms of use that would say you agree there's not going to be a jury trial, and we're going to litigate individual disputes in arbitration as opposed to in a courtroom. The last one I want to talk about, I think, is particularly important, and that is if you have a web developer, an external party that manages your website and has developed your website for you, have an open conversation with them about whether they have analyzed whether your site is accessible. These folks are in this space. They are going to be attuned to these issues. But if the next time you re-up your contract with them, you may want to include explicit promises from them that they will make your website accessible. And a corollary to that is that if someone claims their website is not accessible, they will fix it at their cost, or they will defend and indemnify you if someone comes forward and brings a claim. There's many web developers that have developed significant skills, and they stay on top of the standards as they continue to evolve. So be careful of your contractual arrangement with your web developer, particularly the next time you renew that agreement or you move to a new developer. This is something you can do in advance to protect yourself. All right, we have a couple of questions in the Q&A, so let me go through these. We had a question: how should employers ensure compliance with their career page on their website specifically? That's a whole nother topic, I think. As far as I can tell, the same topics that we've been talking about, making sure your career page is accessible to those, I think that all still applies, right? The same sort of navigation and all that. Collecting information electronically for the use in hiring decisions exacerbates a little bit some of the typical risks, and I don't know if folks are doing a lot of interviews and hiring by Zoom these days. Hopefully that comes to an end soon. But I think the direct answer to your question is the career page is going to be viewed similarly under the same standards that we've been talking about, and it needs to be as accessible as the part about purchasing goods or services. We had another question. I'll read this in. The legal guidance we received after our accessibility review of our career site was that we should make the site as accessible as possible, but ultimately to be in ADA compliance, we just needed to offer an accommodation if there were components we couldn't make accessible due to vendor restrictions. We know that our business shopping site needs to be fully accessible, but it seems there might be different rules for the career site. Well, I think you've touched on one thing that I've mentioned, and that is having a telephone access or another ability for people to submit their application in writing, for example, those kind of things. It's sort of the equivalent of what I said, having a 24/7 telephone alternative in case your website is not accessible. So that's a terrific question, and thank you for the comment there too. Just going to pause. We're right at the 9:30 mark. Just going to pause to see if anyone else wants to add in a question. Hearing none or seeing none. I want to thank you all again for your time this morning. I hope this was informative. If you have any questions, feel free to reach out, and you will be receiving an email that will have a link to the PowerPoint presentation and the recording. And thank you again. Enjoy your day. Have a good one. Thanks.